A very good afternoon to everyone joining us for this session today. I, Parika Gupta, extend my heartiest greetings and a very warm welcome to the respected panelists, faculty members, and our dear participants to the third session of International Conference on Mediation 2022. Today's session would be on the issue of pre-litigation mediation in the context of ease of doing business. Before we begin, I would like to introduce our respected moderator for the session, Professor Anupam Jha, Faculty of Law, University of Delhi. Sir has had an inspiring career as a professor, lecturer, and researcher spanning 2 decades now, with myriad interests and specialization in the fields of international criminal and terrorism law, human trafficking law, as well as law on renewable and nuclear energy. His words of wisdom will surely further the objective of today's session to have an open and constructive discussion on the issue at hand. With this, sir, I request you to formally welcome the panelists.
Thank you, Parika. Am I audible?
Yes, sir.
Good afternoon to all the participants of the webinar. Welcome to the third International Conference on Mediation. As you all know that this session is being organized by Faculty of Law in association with Delhi School of Public Policy and Governance, Institution of Eminence, University of Delhi, in its centenary year, and Mediation and Conciliation Project Committee of Supreme Court of India. This session is titled Pre-Litigation Mediation in the context of ease of doing business. We all know that business is very important for a country's economic growth. Ease of doing business has now become very important to improve overall economic environment. Ease of doing business can be acronymed as EDB, which is an important indicator of the investment-friendly business climate in any country. And therefore, a report was introduced in 2003 to provide an assessment of objective measures of business regulations and their enforcement across around 200 economies on 10 parameters affecting the business through its whole life cycle. These 10 parameters are starting a business, dealing with construction permits, electricity availability, property registration, credit availability, protecting minority investors, paying taxes, trading across borders, contracts enforcement, and resolving insolvency. The latest World Bank report published in 2019 October placed India at a very high rank, that was 63rd in doing business compared to the lower rank in the earlier years. And the government of India has responded very well in improving the ease of doing business in our country. The government of India in May 2020 decided to link grant of additional borrowing permissions to states who undertake the reforms related to business environment. And the data available is that around 21 states of India have successfully completed ease of doing business reforms. And therefore now the Department of Expenditure of Government of India has made these states eligible to borrow additional money from the open market. Despite these positive developments, the challenges in India for ease of doing business are many, such as the need from exemption from approvals and inspections of medium and small scale enterprises, simplifying property registration for industry, enforcing contracts due to less digitalization and e-filing, and a limited number of mediation centers in all parts of our country. So with these challenges, this session is very important today. And we have our guests with us. I welcome the chair of this session today, Honorable Justice of Madras High Court, Justice M. Govindraj, who is the first graduate, postgraduate, and a law graduate in his family. He is the first generation lawyer, as his grandfather was a freedom fighter and his father, Shri M. Muthuraman, was a school teacher in a government school. He is the first judge to be elevated from the bar in Pudukkottai district. He is also a first student to be elevated as a judge of Madras High Court from Trichy Law College. He is also a mediator and mediator trainer from Tamil Nadu Mediation and Conciliation Center, which is the oldest mediation center of our country. He has trained many mediators in various parts of the country. I welcome you, sir, to the third international conference on mediation. He was our guest in the second international mediation also. And I had the honor to welcome him at that time also. We have also with us our co-chair of the session, Honorable Justice of Karnataka High Court, Justice S.R. Krishna Kumar, who graduated from University Law College, Bengaluru, and he joined his father's chambers in 1992. He was elevated to the High Court in 2019, and today we are honored, and his views on mediation will definitely contribute to further growth of ADR mechanism in our country. We have also with us our special guest, Shri G.R. Raghavender, Joint Secretary, Department of Justice, Ministry of Law and Justice, Government of India. He is currently pursuing his doctoral research work in a very important field of IPR from GGSIP University. His inputs to this session would definitely be very constructive and valuable. Another very eminent special guest is Dr. Subhash Chandra Pandey, former Special Secretary, Ministry of Commerce and Industry, Government of India. Perhaps he has joined now. He was a prominent invitee to the advisory group on fiscal transparency and the nodal officer from the Ministry of Finance to interact with the mission from International Monetary Fund. I welcome you, and perhaps his views on mediation, that would be very, very constructive and helpful today. Our last special guest is Shri A.J. Jawad from KD Lex Chambers, whose managing partner is Mr. Jasveer Bajaj, who is an alumnus of Law Center 2 Faculty of Law, University of Delhi. Mr. Jawad is a mediator having an experience of 15 years and is a passionate promoter of mediation in our country. I would now invite the chair of this session to read.
I think Dr. Anupam Jha's connectivity is lost.
So is it that I should start or Jawad starts?
I think Jawad sir will start.
Pardon?
Jawad sir will start because you are chairing the session. You have to speak the last.
Yeah, Professor Anupam said I should start the session. That's why. Anyway, Mr. Jawad will start.
Yes, thank you. Thank you. Honorable Chair, Mr. Justice M. Govindarajan, Judge Madras High Court. Honorable Co-Chair, Mr. Justice S.R. Krishna Kumar, Judge Karnataka High Court. My esteemed co-panelists, Dr. Subhash Chandra Pandey and Shri G.R. Raghavender. Professor Dr. Anupam Jha, Conference Director Dr. Ashutosh Mishra, and my dear friends, colleagues, students who are attending the session today. I'm very thankful to the Faculty of Law, Delhi School of Public Policy and Governance, which is an institution of eminence, and the Honorable Mediation and Conciliation Project Committee, Supreme Court of India, for giving me this opportunity to speak at such an august gathering. Now, the ease of doing business was actually an index created jointly by Simeon Yankow and Gerhard Pohl, two leading economists at the World Bank. The academic research for the report was done jointly by Professors Oliver Hart and Henry Sliefer. The 10 indices which Dr. Anupam Jha pointed out were the basis for assessing the ranking of each country in the context of ease of doing business. Now, unfortunately, what happened was this report was discontinued by the World Bank on September 16th, 2021, following the release of an independent audit of the data irregularities. Now, the audit documented how bank leadership pressured experts to manipulate the results of the 2018 and 2020 doing business reports. However, as long as the report was in the public realm, India was found to have jumped from a rank of 134 out of, I think it was about 186 countries in 2014 to 63 in 2020. And India's biggest competitor and better known, China, ranked 31. Now, let me recount to you a small encounter that I had with the CEO of an American company that was signing a contract with a client of mine. Now, the CEO said that they prefer to do business with China more than with India. I asked him, why is that so? After all, India has better laws, better legal system, and is on par with, which is on par with Western concepts. Our judicial system is designed on a Western format. So even our Indian Contract Act itself is a British Act. So I was a little taken aback with his reply, which was, he replied that you have the laws, but where is the resolution? No investor likes to wait for years to resolve any disputes that may arise. Now, the CEO went on to tell me that it does not take more than 3 months to resolve a dispute in China. Now, I don't know how far that time frame is true, but obviously he has no reason to lie. Now, in India, as Dr. Anupam Jha also pointed out, that factors like relaxing of procedural rigors and starting businesses have been implemented. Perhaps that is one of the reasons why India jumped from 134 to 63 when the ease of doing business ranking was a valid criteria. But dispute resolution is still lagging behind, notwithstanding some seemingly progressive legislations like the Insolvency and Bankruptcy Code in 2016. Now, recovery under the code is far more than recovery under the earlier regime. Now, yet there are some challenges which are yet to be resolved. Now, the biggest concern is that as per the IBBI data, over half of the cases closed under the corporate insolvency resolution plan ended up in liquidation, and only about 14.93% ended with a resolution plan that was approved. Now, this data somewhere shows that this new system is running away from its intended purpose. The other challenge is that the largest NPAs are not yet resolved. Now, to add to that, the COVID-19 pandemic posed a new challenge to the code. Businesses suffered tremendously on account of demand and supply chain disruptions and receding sales and revenue caused by the pandemic and the nationwide lockdown. At the same time, the pandemic has shown us an opportunity to innovate and explore new ways of resolving disputes. Special out-of-court procedures like mediation, particularly online mediation, have proved to be quite successful in resolving disputes. Mediation can help reduce the burden of increasing cases on the already overburdened judiciary. Mediation can be a viable option in a country like India, where the population is enormous and wealth is not equally distributed. As we all know, it's an informal process that comes to an end in a few sittings. It is very cost efficient compared to the formal process in the courts of law. This is because the focus of mediation is on finding solutions that will resolve the concerns of both the parties concerned, and parties are free to make their own decision. There is no blame game in a mediation process. It is a voluntary process, and the duty of the mediator is to bring the parties to a mutually agreed solution. But despite all these benefits, mediation has had to face quite a struggle to become the court of first call, the court of first call, before taking recourse to adjudicatory processes like litigation and arbitration. What is really required, what is really important, is a change in the mindset of business enterprises, lawyers, and other stakeholders. Now, it is usually seen that big businesses do not settle easily. It's mainly because the decision makers usually don't take part in the mediation process. Sometimes the dispute is against a smaller and financially weaker entity, and the big business thinks that it can wait out the litigation, by which time perhaps the smaller entity will lose the wind in its sails. Also, lawyers feel that their advice to settle may not be appreciated by the big clients, and they may perceive it as a weakness or lack of confidence on the part of the lawyers. Now, until recently, we used to see a tendency to look down upon mediation as a very poor cousin of litigation and arbitration. Now, such a tendency still persists in certain sections of the legal community who still suffer from the colonial hangover of believing that adjudication is the only way to resolve disputes. Now, we have a slew of legislations that prescribe mediation, starting with, of course, Section 89 CPC, which came into effect way back in 2002. But it was sort of a dead letter law. But that again pertains to cases that are already pending before the court. And that was revitalized and given a new life by the judgment of the Supreme Court in the very famous Afcons. Now, we have also the Commercial Courts Act, we have the Companies Act, we have the Consumer Protection Act, we have the Real Estate Regulation Act. All of these mandate mediation. Now, Commercial Courts Act stands on a different footing because it mandates pre-institution mediation. But there are several loopholes in it that need to be plugged. For instance, if an interim order is required, the plaintiff can bypass the mediation and approach the court directly. This is just one of the loopholes that I'm pointing out. Now, as we all know, there's a new law on mediation that is expected to be enacted soon. It will hopefully plug these loopholes as it provides a mechanism for seeking interim orders from the court, even while you go in for mediation. Pre-litigation mediation is sought to be made mandatory. An exemption from the application of the Limitation Act for the time spent in mediation is provided. And the agreement that is reached in mediation, what is called as the mediated settlement agreement, has the efficacy or the force of a decree of court. Now, I'm an eternal optimist and I sincerely believe that the future looks very hopeful. We have come a long way in the past decade and a half. There is a growing awareness among lawyers in particular, who are now boldly recommending mediation to the clients whenever they feel it is appropriate. The former Chief Justice of India, Honorable Mr. Justice S.A. Bobde, as well as our present Chief Justice, Honorable Mr. Justice N.V. Ramana, have repeatedly emphasized on the importance of mediation as an ADR mechanism. And they have observed that all commercial matters should be made to first go through pre-litigation mediation. It is hoped that the new Mediation Act will be a game changer and will perhaps elevate the perception of mediation in the eyes of the stakeholders and enable them to explore the less costlier and more time-efficient process like mediation. Thank you very much. I hope I completed in the 7 minutes that were allotted to me. I did not exceed my time. So thank you once again for the opportunity.
Thank you so much, sir, for your valuable inputs. It was a very comprehensive, holistic, and solution-driven session. With this, I would now like to invite our special guest, Dr. Subhash Chandra Pandey, sir, to share his views on the topic. We humbly welcome you. Over to you, sir.
Good afternoon, gentlemen, ladies and gentlemen. On this session on the mediation, I would like to focus in my short intervention on the aspect of mediation bill where government or government agencies are parties. And my preceding speaker, he was mentioning about the ease of doing business and the parameters that go into this. In a large measure of this interface with the investors and the government is what influences the ease of doing business parameters. And this happens usually at a stage where much before the actual contracts materialize, where there is a stage of seeking clearances, where there is in terms of whether it is building construction permit or taking licenses for commencement of business, etc. So it is not very usual for these issues to fall in the area of adjudication or mediation. That usually happens much after the businesses have commenced although there have been some cases, which have gone into international arbitration, where it was alleged that the states and the central government had given certain assurances, held out certain assurances to the investors while inviting them to set up businesses in the territories, including the tax concessions, etc. And then those promises did not materialize. So it was invoked about the investor protection treaties, bilateral investment treaties, economic cooperation. So I noticed that in this bill on mediation, a very clear distinction is made in terms of what can be taken up for mediation is a class of disputes where government or government agencies are a party. So unless the government notifies particular types of classes of disputes that will be taken up for mediation, of which there is no clarity as of now as to what will be those class of disputes. And the second one is, of course, where international arbitration is provided. So since, as I mentioned, in the case of ease of doing business, usually it doesn't start as a formal contractual obligations. These are general policies and procedures of the government open to everyone without any specific contracts there, which could be enforceable in a court of law. And therefore, the scope of pre-litigation, mediation, etc., in my view, is limited in such. But nevertheless, mediation as a role to declog the judiciary, which is overburdened with the huge areas of caseload, that cannot be sort of overemphasized. And it will help definitely when the judicial areas are taken care of by the mediation process. In general, the commercial dispute resolution and other processes will get faster. And to that extent, mediation would indirectly help improve the business ecosystem, improve the enforcement of contracts, which is the parameter which has been pulling us down in a very substantial manner. With these brief remarks, I conclude. Thank you.
Thank you so much, sir, for taking this discussion forward and highlighting some very crucial points on the issue of mediation and the associated bill. Now, I would like to invite our special guest, Shri G.R. Raghavender, sir, to share his knowledge of the field. We welcome you, sir. Over to you.
Thank you. Vande Mataram. Good afternoon to all distinguished panelists, especially Honorable Justice Govindaraj from High Court of Madras and Honorable Justice Krishna Kumar from Karnataka. Namaskara. And my senior colleague from DPIIT, Gupta sir, namaskar, and also Mr. Jawad. And thanks, Mr. Ashutosh, for inviting me to speak to me, because topic is very dear to me. And it was my itch to introduce this in the Commercial Court Act. When I joined the Department of Justice, I always feel proud that the initiative which we took, now it is being implemented, and it is one of the legal tools to reduce the time taken for resolution of commercial dispute in the specially established commercial courts all over India under the Commercial Courts Act 2015, which was introduced by Government of India under the leadership of Sri Narendra Modi, Prime Minister, to improve the resolution of commercial disputes, because the enforcing contract is one of the 11 indicators of the ease of doing business. I always keep telling that enforcing contract is the heart and soul of ease of doing business, because any commercial dispute arises in other 10 indicators. This is the 11th indicator that the enforcing contract gives the relief. So if any delay happens, then there is a big problem. Any infrastructure problem or any Make in India project can't go ahead if litigation hampers the very starting of the business. So World Bank in the assessment, three aspects they calculate. One is the time taken for the resolution of commercial dispute, then cost involved in the resolution of the commercial dispute, and quality of judicial processes we follow, like case management, court processes and court management, and court automation, and finally, the ADRs we are following in these commercial court. One of the main ADR thing is voluntary pre-institution mediation mechanism has to be introduced. So when we try to explain that, in the Salem Bar Association case, Supreme Court, Honorable Supreme Court, Apex Court of India has already explained that Section 89 of CPC includes all forms of mediation. And even recently, Supreme Court has said in Ofcom case that mediation is one of the important ADRs which flows from the Section 89 of CPC, along with other ADR mechanisms like arbitration, conciliation, lok adalat, and all that. But they wanted a special provision and the pre-institution mediation happening, because all Section 89 mediation cases happen court annexed mediation, because what the assessment technique says that before a commercial suit is filed, it has to go through a mediation process, not the court annexed mediation after the casing matter is filed. Honorable judge will say that go for the mediation first, then you come for the trial. It's not. So initially a mediation process to be there. For that, we have to take great pains in convincing the legal affairs department, and we drafted a little thing. We rushed to the then law minister, Sri Ravi Shankar Prasad, and we have to get support from PMO to that. And PMO fully supported our draft. Then finally it went to legislative department. They improved it, and thanks to late Sri Narayan Rajuji, who passed away recently because during the COVID wave 2, he was Secretary Legislative Department, and it was his idea. Simply introducing pre-institution mediation settlement is not enough unless and until such settlement is not given legality, similar to the arbitration award. So he himself wrote down that subsection 5 when I took the draft to him. It was a beautiful idea to giving the legality to the settlement, bringing the section 34 of the arbitration, that is arbitration award, legality to the settlement of the pre-institution mediation, because the mediation bill, which gives legality to all kind of mediation, soon going to be approved by the parliament. But in 2019, there is no bill and no legality for such settlement, because commercial disputes have to be resolved a faster manner and in a cost-effective manner. This is the best legal tool we introduce. Then PMO suggestion was because they said, which institution will do that? It was their suggestion that, we have already, there is a legal services authority bill. There is a most effective, legal umbrella called NALSA, SALSA, DALSA there. The effective mediators are there. So let them take over this and start doing that. Beauty of this NALSA system and DALSA, SALSA working is, now there is a NALSA mobile application. Those who have downloaded NALSA application, mobile application, they know that, they can file online application before any commercial dispute is there. Let us say intellectual property dispute. I'm an intellectual property law person, and there is a patent dispute or copyright dispute. There, reason why we introduce interim relief, immediate urgent relief, because the intellectual property is infringed, whether it is a film or a software or a trademark. You can't go and doing the mediation when lakhs and crores of rupees are being damaged, my brand name, or my film, let us say the RRR, which is already grossed 900 crores, has been illegally uploaded. Of course, the High Court Bangalore or High Court Madras or Delhi have to give immediate urgent relief under the John Doe orders to block all those things. If they go for mediation, sometimes the unknown people are uploading it. Beauty of the John Doe order is that will stop even unknown people. That injunction is given to block all the links and the links which appear in future as well. So that is the important. Of course, it may be a big reason for delay is non-successful of this mechanism is everyone is claiming that I want interim relief, urgent interim relief. No, that's not done. One has to file it because it's a mandatory thing, but with opt-out option, because the entire mediation has to be voluntary. You can't force someone. If I'm a party, the filing application for the pre-institution mediation, my opponent party deliberately can't be dragged if he is not willing. So opt-out model is there. Then if he agrees, then the minimum time limit is given for the mediation and the extension of first 3 months time is given, timelines. And if that is not successful, then extension is given. But it will take very less time. Time taken is not more than 120 days, because the average time taken for the top country in the ease of doing business, Singapore, is 165 days for resolution of commercial dispute. That is filing, summons, trial, argument, and enforcement. In India, average time taken is 1440 days. Now, with the constitution of dedicated courts in Delhi and Mumbai, Delhi 22, now there are more 42 are they're going to set up, and Mumbai 6, and Bangalore, thanks to my personal visit to the then Chief Justice Okan, now the Supreme Court judge, and he understood the importance of policy initiative of the government. In my meeting with him in a couple of times in his chamber in Karnataka High Court, we draw the model, and he took up the Delhi model of setting up a dedicated court for every 500 pending commercial cases. They have set up around 9 courts, and he inaugurated before he left for the Supreme Court in the Bangalore nearby Vidhan Sabha BSNL building. 9 courts, they have set up 8 for urban and 1 for rural. They also started the pre-institution mediation. We have made available one beautiful portal, EODB Enforcing Contract portal, in that Bangalore, Delhi, Karnataka, and Mumbai, and Kolkata, all 4 ease of doing business assessment sites. They have included entire data, because there is a commercial courts statistical rules data as per that. Also as per the pre-institution mediation rules, they have to create the data, number of application filed for the pre-institution mediations, number of things which are not completed and which have been settled, which are pending. The entire data is available from all these 4 places, Bangalore, Delhi, Kolkata, and Mumbai. And the best performing commercial courts are from Bangalore and New Delhi. And then my salute to the judges and the mediators doing great job there, including advocates, of course. We can't forget the major stakeholders. They're doing the great job. And the next step in finalizing this include introducing ODR for this purpose. We are working with NALSA to have a dedicated ODR platform for the pre-institution mediation, because pandemic has taught us. My law minister has proudly announced that Supreme Court has become world leader by hearing more than 181,000 cases. Of course, district courts more than 10 crores and high courts more than 6. I think about 60 lakh cases. There are 25 high courts. So these are the developments. Of course, mediation bill is coming, and we suggested that with the success of this mechanism, a legal tool, pre-institution mediation, it has to be spread to all civil cases now. Not only for the commercial court, which Commercial Court Act allows, it should be all cases. So the pendency of 4 crore cases in India has to be reduced because of this legal tool. That is the thing. And it has to come with the ODR mechanism. Another important thing is awareness has to be increased among the stakeholders that no, you can reduce the money and you can save the time. But unfortunately, with my experience, I don't want to criticize lawyers. In my field study in the Delhi 22 courts and Mumbai courts, Bombay City Civil Courts, lawyers are not happy because they say that the rules which prescribes the fee is higher side. That because the Prime Minister already announced reduction of compliance burden. So that is one of the duties of my department, to reduce the compliance burden, reduce the fee. We already formed the committee, and hopefully we'll do some disruptive changes that the pre-institution mechanism will work more efficiently. Of course, mediation bill, once it becomes the law, it will include this pre-institution mediation for all cases. And another thing is plea bargaining, some success we need to see in that area also. Thank you, sir. Thanks a lot. I think I've taken little more extra time. Jai Hind.
Thank you so much, sir, for sharing your valuable and knowledgeable insights on mediation in ease of doing business and the associated technical issues and solutions with all of us. Now, I would like to invite the co-chair for our session, Honorable Mr. Justice S.R. Kumar, Judge, Karnataka High Court, to share extensive knowledge on the issue and further enrich the discussion. We humbly welcome you. The virtual platform is yours, Your Lordship.
Right. Good evening, Honorable Justice Govindraj. Good evening, eminent panelists, ladies, gentlemen, and students. Now, all of you already heard this, but let me repeat. Ease of doing business is the World Bank's index of ranking various countries according to prevailing business regulations on the basis of 10 indicators. Of these pointers, contract enforcement is one. While this parameter has traditionally measured dispute resolution through the local court system, in recent years, the focus has broadened to include mechanisms of alternative dispute resolution, ADR, in particular, arbitration, voluntary mediation, and conciliation. Unlike arbitration, in a mediation and a conciliation process, the parties ask a third person to assist them in reaching an amicable settlement of their dispute. Economies with a system that integrates courts and ADR tend to have more reliable judiciary, the parties involved and the economy as a whole. Effective systems of mediation matter a lot to investors. Lawyers and business owners know that high litigation costs and long delays make resolving commercial disputes in court difficult and expensive and may look elsewhere for dispute resolution. And businesses may pass the costs on to consumers or abstain from investing in a jurisdiction. Especially in smaller cases, having a neutral mediator or arbitrator saves businesses time and money in resolving commercial disputes, control over outcomes and confidentiality. And with today's increasing complex business dealings, specialized ADR programs focusing on particular types of technical or complex disputes can be more effective and produce better settlements than courts, increasing litigants' satisfaction with outcomes. Now, in the Indian context, as already stated by some of the speakers, India fared extremely well in 2019 and even jumped 14 places and was ranked 63 in the list. It did not do so well in the contract enforcement indicator. India continues to struggle with this and was ranked 163rd under this head. The 2018-19 economic survey bemoaned India's inability to enforce contracts and resolve legal disputes as arguably the single biggest constraint to the ease of doing business in India. The establishment of commercial courts exclusively for efficient resolution of complex business disputes was the key policy measure introduced by the government to improve India's position on the reinforcement of the contracts indicator. It was touted as a major step towards reform of India's civil justice system to ensure quick enforcement of contracts, facilitate easy recovery of monetary claims, and the award of just compensation for damages. This would encourage investors to establish and operate businesses in India and result in rapid economic growth. Pre-litigation mediation has been considered to be a panacea in this regard, as available research suggests that mediation may well increase the overall natural rate of settlement at a lower cost and within a shorter time frame than comparable litigation. Before the Commercial Courts Act came into effect, data from Delhi also provides us with an interesting trend to buttress this hypothesis. Of the cases that have been settled, issues had been framed only in 9 matters, that is 20% of these cases. This means that out of 45 cases that were disposed of, 80% of the cases were settled at the pre-trial stage, even before issues had been settled. Now, coming to the Commercial Courts Act. The Commercial Courts Act, which again has been spoken to by some of the speakers, identified commercial disputes as a class of disputes, established commercial courts and commercial divisions within the civil court system to adjudicate these disputes. It compressed the procedures in the CPC, that is Civil Procedure Code, to expedite adjudication of such disputes. In 2018, this law was amended. Section 12A was added, which required parties filing a suit under this law to first attempt to resolve their disputes through mediation, unless an urgent relief, such as an injunction against use of a trademark, so as to say, for example, is required. The Commercial Courts Act 2000, the Rules 2018, have been notified that set out the process for availing pre-institution mediation through legal services authorities at the state and district levels in each state. Now, Mr. Jawad was talking about an amendment to the Act, that is Section 12A, in order to bring about a method or a mechanism by which pre-litigation, some protection is given to a party so that he avails pre-litigation as a voluntary, if not a mandatory option, so as to enable the party to voluntarily submit himself to pre-litigation mediation. Now, the issue with regard to whether 12A is mandatory or directory, that issue itself is still at large. So in that context, I would like to cite a couple of judgments. In the case of Deepak Raheja versus Gangataro Vaznani, the division bench of the Bombay High Court said that 12A is mandatory in the case of a commercial suit of a specified value, and such a proceeding cannot be instituted unless pre-institution mediation has been exhausted by the plaintiff. Then a learned single judge of a Calcutta High Court in Lakshmi Polyfab versus Eden Realty observed inter alia that plaintiff does not have an unconditional right to approach the commercial court or a commercial division of a high court to have an issue involving a commercial dispute within the meaning of the Act without adhering to Section 12A. The same bench in another in the case of Dredging and Desiltation Company versus Macintosh, Byrne and Northern Consortium observed that the object of the Act is to expedite disposal of a commercial dispute, which is achieved through compulsory pre-institution mediation. A similar view was expressed by the Allahabad High Court in Avasti Motors versus Managing Director. Now, interestingly, Mr. Justice Govindraj would know this. In Shahi Exports Private Limited versus Gold Star Line Limited, authored by Lordship Justice G. Jayachandran, the Madras High Court said that the right to access justice, which is a constitutional right, cannot be denied or deprived for not resorting to mediation. Further, the court is not a substitute to alternative dispute resolution mechanisms, but it's the other way around. And the use of the word shall in Rule 131 of the Mediation Rules, Commercial Court Rules 2019 was taken into consideration. A harmonious interpretation of Section 12A and Rule 31 of the Commercial Courts Rules, court concluded that 12A is not mandatory, but only directory, and that a litigant could not be denied the doors of justice for directly approaching the court without exploring the possibility of mediation. Now, why I'm stating this is the question with regard to Section 12A being mandatory or directory, that itself is still at large. And the question of then the issue with regard to carrying out amendment would necessarily have to be looked into or considered after this anomaly in the Act is addressed. Now, my humble suggestion is that if a person, for the purpose of ease of business or for any other purpose, if pre-litigation has to effectively work, some protection has to be necessarily given to a person, offered to so as to entice him into voluntary surrendering and subjecting himself to pre-litigation. If you're not going to protect his interest, now Mr. Raghavender said that crores of rupees, RRR earned, grossed about 900 crores. If the links are stopped, they lose out. Well, there has to be a balance. Now, if you're going to encourage ease of doing business by enticing parties into getting into pre-litigation mediation, you have to protect them in some manner. There has to be a balance between parties ventilating their grievances, giving them protection, and at the same time, without getting into litigation. So these are aspects which I think the government, central government, will have to look into and address, and at the earliest. Otherwise, the provision remains the same. We judges go on writing judgments. I sit in a single bench, I write one judgment, the division bench reverses it, the Honorable Supreme Court confirms it, nothing is going to happen. So serious introspection into the actual workability of pre-litigation mediation is something the central government will have to look into. Then, as per the way Doing Business Report 2020 of the World Bank, interesting developments have been observed, especially in the global south, for easier enforcement of contracts by placing mediation at a centerpiece. Without naming the countries, just a few aspects here. One is introducing e-system that allows plaintiffs to file the initial complaint electronically. Number two, adopting a law that regulates all aspects of mediation as an alternative dispute resolution mechanism. Number three, establishing specialized commercial court divisions and by adopting a framework for mediation and conciliation, including in commercial cases, adopting a consolidated law on voluntary mediation, then introducing a simplified procedure for small claims, setting time standards for key court events and limiting adjournments, then establishing financial incentives for parties to attempt mediation, and then lastly, publishing performance measurement reports and on local commercial courts. And last but not the least, appointing competent person to man the judiciary, competent person who are in charge of the system. I don't need to say more, because ultimately, end of the day, it's the personnel, including all of us, that will have an impact on whether pre-litigation mechanism works or not. Then, in the light of these, India has established commercial court divisions and adopted a framework for mediation in commercial courts, as can be seen in the enactments. Now, the mediation bill is now tabled before the parliament. They are looking into it. I acknowledge, rather, I'm grateful to Mr. Raghavender for pointing out how the Karnataka High Court and the 9 commercial courts are doing wonderful work here. We have taken great pains, we meaning especially Justice Abhay Srinivas Oak, the Honorable Chief Justice as he then was, has taken great pain in not only setting up dedicated commercial courts, but also identifying good personnel, good judges. And interestingly, from the feedback what we get, they have received the training, it's a specialized training. They have received the training very well and they're functioning very well. Because we as appellate judges dealing with commercial appeals come across judgments day in and day out. And surprisingly, the judgments are extremely well written, of course, with a few aberrations. But the quality of judgments that come out of the commercial courts from the dedicated and designated commercial courts are really very refreshing. That shows the nature of training being given and the efforts of the state government and the central government in this regard. So, hoping that the pre-litigation mediation will progress, and by the next conference, we'll be in a position to report statistics of a much higher nature. I would like to thank all of you for giving me this opportunity. Thank you.
Thank you so much, Your Lordship, for comprehensively apprising us about the entire process of mediation and the newer challenges, aspects, and the relevant judgments associated with this mechanism. Now, I would like to humbly invite the esteemed chair for today's session, Honorable Mr. Justice M. Govindraj, Judge of Madras High Court. It is an honor to have you here with us, sir. Over to Your Lordship.
Mr. Govindrajan, I think you will have to unmute yourself.
Co-chair, Honorable Mr. Justice S.R. Krishna Kumar, Judge, Kannada High Court. Mr. G.R. Raghavender, Joint Secretary, Department of Justice, Ministry of Law and Justice. Dr. Subhash Chandra Pandey, former Special Secretary, Ministry of Commerce. Mr. Jawad, my partner in training, mediator and partner and head of ADR services, KD Lex Chambers. Mr. Professor Dr. Anupam Jha, who was always generous in complimenting me. Dr. Conference Director, Dr. Ashutosh Mishra, and the computer Farika Gupta. Ladies and gentlemen, good evening to you all. Now that all the speakers have covered the entire topic of ease of doing business and in the importance of pre-litigation mediation. As Mr. Subhash Chandra Pandey said, these 10 parameters of bringing the economic development, bringing foreign direct investments, public-private partnership, all this to be followed and made easy to do away with its license Raj. And the 11th parameter, as indicated by G.R. Raghavender, of this enforcement of the contract, are all taken care of much by these lawmakers. Mr. Raghavender must be aware, and he was he played a major role in drafting the Commercial Courts Act, considering this global economic environment where business has become very competitive, and to improve the economy of this country, we need to do all things which can improve India in ease of doing business. As Mr. Jawad said, India was crawling at 142nd place out of 189 countries in the year 2015. And it was slowly improved to 130th place in 2016. And now 63rd place in 2019. And it's a remarkable improvement. And this is all because the economic policies taken by the central government and the Commercial Courts Act plays a very vital role. And more particularly, the pre-litigation mediation is very doing so much of improvement in this. Maybe Mr. Raghavender might have been influenced by the Italian system, where Italian government successfully tackled the notorious delays in civil justice system through effective pre-litigation mediation. The Italian government passed a law number 69 of 2009 delegating a mandate to the Italian government to regulate civil and commercial litigation, commercial mediation. And the Italian government also responded immediately and passed the legislative decree 28 of 2010, making pre-trial mediation mandatory. It is always the response will be very tough, particularly among the legal fraternity. The National Lawyers Union of Italy, they went on a strike and they challenged this pre-litigation mediation, compulsory pre-litigation mediation. A 15-member panel of Italian Constitutional Court set aside that decree on the ground that it is not expressly delegated by Italian government, so that once again a law decree was passed stating that this compulsory pre-litigation mediation will be there for 4 years. Phenomenally, the result was that 43% of the cases were settled in pre-litigation mediation. The people of Italy now first attempt to pre-litigation mediation and reducing the burden of the legal system. Here, in this country also, pre-litigation mediation has taken off well, but the procedure is that you have to go through the Legal Services Authority. And it is in a way that so far we have dealt with court-referred mediation. Now it is a pre-litigation mediation, and we need to create an infrastructure, effective infrastructure. As Mr. Justice Krishna Kumar said, we need to appoint efficacious and efficient mediators, well-trained mediators, and constitute a separate commercial dispute resolution cell, and then refer all the cases to those who are pending cases, and also the pre-litigation mediation to that particular cell, so that it can effectively can settle all the cases, and it will improve the economy of this country. Mr. Jawad said that there is a loophole under Section 12A that it makes that without attempting to pre-litigation mediation, we can go to straight away approach the court when there is an urgent contemplation of urgent interim relief. It is true, when there is an urgent interim relief is contemplated, the parties shall be permitted to approach the court. But in majority of the cases where the pre-litigation urgent interim relief is not contemplated, naturally these commercial parties would go and approach the pre-litigation mediation. Now that the government has made the procedure easy, and it will be in future, it will be made more easy. And slowly, as Italian government made 43% result in settling the matters through pre-litigation, India will also improve its stand by settling the matters slowly, gradually, but definitely it will achieve pre-litigation mediation and facilitate ease of doing business in India. Mr. Justice S.R. Krishna Kumar said, this situation is still open, but in my humble opinion, in the Deepak Raheja's case, the division bench of Bombay has discussed all the points with regard to 12A and has held the pre-litigation mediation is a mandatory one, because only when there is urgent relief is contemplated. In all other cases, it must be that every party should be compelled to go to pre-litigation. The other point Mr. Krishna Kumar, Justice Krishna Kumar pointed out, it's a voluntary process. So voluntariness comes only when the process takes place. Normally, when you take a person or a litigant, or you compel a person who's going to litigation to undergo this mediation process, the participating in the process, undergoing the process can be voluntary, but compelling them to go and approach and doing this need not be voluntary. Then you can compel the party to go participate in that. If you are not willing, then you can come back and approach the court for getting dispute resolved by the court. As Mr. Jawad said, we are the colonial hangover of doing adjudicatory dispute resolution. But you have to introduce and propagate that India has so much of facilities and it has speedy and effective and affordable dispute resolution. So once dispute resolution is very easy, and parties, particularly these foreign players, can come and they can immediately invest in this Indian country. And other cases that, and Deepak Raheja, when it is made mandatory, that many cases have, many courts have followed the judgment and now they've made it mandatory. And I should mention the judgment of Supreme Court in Vikram Bakshi versus Sonia Khosla. The Supreme Court said mediation is a new dimension of access to justice. That is one of the best forms, if not best, of the conflict resolution. So mediation, it has become a best form of conflict resolution. And this country, as our law minister has told in the parliament, we have enough infrastructure of trained mediators, mediation centers, and we are trained in Madras, in Tamil Nadu. We have, as a member of the mediation committee, we have sought to that each taluk center has at least minimum 4 mediators, and we have sought to that there are infrastructure available, internet facilities available for the parties to participate in the mediation effectively. So now that we are contemplating of forming a special commercial code dispute resolution cell, having all senior advocates and efficient lawyers to facilitate the early disposal of the cases. Now that the disposal of pre-litigation mediation is set to three months, and if it's required, another 2 months time is granted, extended. In this process, there are a lot of gray areas. As Honorable Mr. Justice Krishna Kumar said, there are places where how to decide whether this case contemplates urgent relief or not. The registry cannot do that because they have no authority or competency to decide that. Unless it is numbered, the court cannot say that it contemplates urgent relief or not. In certain judgments of courts, particularly the Telangana court, in a case when they are examining the urgent relief under section 12A, they have considered the point when they found that there is no urgent relief, they have not rejected the plaint, but they have made the plaintiffs go back to undergo this pre-litigation mediation and have come to the mainstream later. Likewise, Calcutta High Court and other courts, they have not rejected the plaint, but returned the parties, kept it in abeyance. They kept the suit in abeyance and directed the parties to undergo pre-litigation mediation and then come back after, if the matter is not settled. If it is settled, then that's the entire issue is resolved. In one case, plaint was rejected for not undergoing, not complying with 12A, not undergoing pre-litigation mediation. Again, the party approached the mediation when he found that the mediator rightfully said, I cannot grant you that urgent relief. Immediately, he abandoned the mediation. He approached the court again under Order 38 Rule 5, obtained the interim orders, the suit was entertained, and it was taken cognizance of. So, there are hiccups there, here and there in pre-litigation mediation that hopefully there is an appeal against the judgment which says it is directory rather than it is mandatory. It is pending before Honorable Supreme Court of India. We hope that it will, the Supreme Court will lay down the appropriate decision so that it will facilitate the improvement of and the economic development of this country. Sir Geoffrey Voss, Master of Rolls, has said, Now that the alternate dispute resolution has to go, that it is an irrelevant statement. There is no alternate. The dispute resolution itself is the integral part. And particularly mediation plays the vital role in this and it is the future of this country. And more so, that online mediation has proved that major bulk cases are settled, particularly during pandemic. So the pre-litigation mediation will definitely facilitate and enforce the contract so that the doing of business will become very easy and India will achieve the highest place. Thank you so much for giving me this opportunity. I think we have to finish up at the right time. So I close my speech with that.
Thank you so much, Your Lordship, for taking us through the very intricate details of mediation and beautifully capturing the entire essence of the discussion. It indeed provided us with in-depth knowledge on the mechanism. With this, we reach the end of the session. It was indeed a thought-provoking one and instilled more mindfulness on the issue of mediation. Now, I would like to call upon my respected moderator, Professor Anupam Jha, sir, to share concluding remarks and present the vote of thanks to our esteemed panelists.
Keeping in mind the time constraints, I would just like to give my vote of thanks. Having enjoyed the informative and quite useful session, I have the privilege of extending the vote of thanks on behalf of Faculty of Law, Delhi School of Public Policy and Governance, and MCPC Supreme Court of India. I thank Honorable Justice M. Govindraj for agreeing to grace today's event, despite his busy schedule and despite his many commitments. This shows that how close mediation is to his heart. Rightly, he stressed the need to improve the ease of doing business in our country in the light of huge competitive business environment in the world. It was enriching to hear how Italian example influenced the making of pre-litigation mediation law in our country. Rightly observed by Justice Govindraj, the court referred mediation and pre-litigation have been working successfully in our country. This success would definitely go a long way in improving the EDB ranking of our country. Justice Govindraj's observation has gone a long way today in making mediation successful in our country. I must thank Justice S.R. Krishna Kumar, Judge Karnataka High Court, who observed that India is not favorably ranked in contract enforcement, and this establishment of commercial court has helped in crossing this hurdle. And according to him, it's a major reform which is made in the recent times and which would definitely result in the overall economic growth of our country. Rightly observed by him that the judgments of the courts, whether Section 12A is mandatory or directory, that has not been settled till now, which needs to be settled. And he rightly said that serious introspection is needed to improve the pre-litigation mediation in our country. So his observations will definitely help India in improving the EDB ranking. And I must thank him for sharing his experience and letting us know his observations. I must thank G.R. Raghavender, who shared his experience, how he helped the government in introducing mediation in the Commercial Courts Act. He defended the mechanism of urgent relief and opt-out in the act. And he also cited judgments, how mediation is reiterated as a favorable mechanism in commercial disputes. And therefore, what he said that mediation must be made mandatory in all the civil disputes. So I thank him also that his observations are very crucial today, and that will definitely help in the success of this conference. I am also thankful to Shri Subhash Chandra Pandey ji, who shared his experience and observed that the executive has a larger role in the EDB ranking, and the adjudicatory process has a limited role, and that is very important. Therefore, what he said that the executive has to do all the preparatory work, and then the law will come. And the new Mediation Act, he has a lot of, he sees a lot of potential in the new Mediation Act. And he says that it may declog the judiciary of its docket burden, and finally it would improve the EDB ranking of our country. So that these observations are really very fruitful and helpful. I'm also thankful to Shri A.J. Jawad, who gave examples showing that how China is the preferred business destination than India. He gave many examples, real life examples, and suggested a couple of reforms by which he is hopeful that the new Mediation Act would be definitely a game changer. So his observations are really very helpful. So today's program has really given us a lot of clues by which mediation can be very successful in the improvement of our business environment. I thank all the legal luminaries and other dignitaries present today, and all the virtual participants for joining today in such a time. University of Delhi is now having exams, and therefore some students have also joined. And I thank all the judges from different courts and High Court and Supreme Court. I am also thankful to the organizer of this program. So in these times, Ashutosh Mishra has organized this event proactively and successfully. So he should be congratulated today. I congratulate Dr. Kisla Soni also for successful coordination of this program. Thank you very much. I wish all of you to be safe and stay blessed. Thank you.
Thank you, Anupam Ji. Thanks a lot.
Thank you all.
Thank you, sirs.
Thank you, sir.
Thank all of you for joining us today and making the session a huge success. I would request the participants to kindly fill up the feedback form for the certificates. Thank you and have a very good day.